Most San Francisco tech startups have one thing in common. They're trying to grow as quickly as possible. That often means facing the arduous process of hiring foreign nationals.
There's just a war for talent right now out in the software world. We want to make sure the entire process just runs smoothly from the time that we've identified a candidate to the point where they're sitting at their desk in our office.
Nason works at a web and mobile application development firm in San Francisco with an immigration lawyer on speed dial.
Hey, Stephanie, how are you?
Good. How are you doing, Andy?
It started with me doing my own research on what is involved in bringing a candidate from overseas into the U.S. to work for your company. And it was through the course of my research that I realized that this was far beyond my capability, and it made the most sense to go to an immigration attorney.
At issue is this, the H1-B visa application. When approved, it allows well-educated or highly skilled foreign nationals to work in the U.S. for up to 6 years. And it is a legal minefield.
This is not a process I would recommend trying on your own.
Kirsten Schlanger is one of San Francisco's top business immigration attorneys. She says employers must not only pay the fees for an H1-B petition, but also navigate a very complicated application process.
To put together an application, overall from start to decision can be at least 4 weeks up to several months. The cost is going to run you somewhere between $7,000 to $10,000 depending on the complexity of the petition. And it's a complicated petition. It's a lot of documentation and a lot of filling out the right boxes. If you make a typo or if you don't coordinate something, an application can get kicked back and then you've missed your deadline.
That annual deadline is April 1st. If an H-1B application isn't in by then, a new applicant has far less chance to get one of the 85,000 new visa numbers distributed that year. Schlanger says several factors can throw a wrench into the H-1B process. If a current H-1B visa holder is nearing the end of the standard 6-year maximum stay, if a visa holder has been unemployed for more than a week and remained in the U.S., if a prospective employee has previous immigration violations, or if the government's prevailing wage for the position is much higher than the employer's proposed wage.
I know complexity and immigration law, it's a mind bender because much of what happens is not in the law. It's in memos, it's in practice, it's in just knowing who to call to find out what is the current situation for this particular scenario.
In San Francisco, this is Claire Major for the Lawyers.com channel.